until he is seated and sworn in to tell the truth and so under oath. Ms. Bird, you may resume cross-examination.
For review where we were. On June the 6th of 2015, the defendant met with his probation officer and indicated that he had an interaction with police that he was somewhat upset by.
Yes.
And then on June the 7th, he posted under the name DA Real T Streets, which you have said is his Facebook name, correct?
That's his Facebook name. I've never seen any records to indicate what you're speaking of. I understand you indicating that they were provided, which I was not the first mitigation specialist on this team. I have not reviewed those.
Ms. Hall, did you receive Facebook information in discovery indicating that the defendant went by the name DA Real T Streets? And did you receive his entire Facebook history as part of discovery?
I have not reviewed his entire Facebook history as part of discovery.
So that's not information you thought important when determining whether or not there was mitigation? Those photographs that you presented in your presentation, those didn't come from his Facebook page?
No, those are provided by family.
So you weren't aware that on June the 7th of 2015 that the defendant posted a photograph of a police officer being beaten by 3 men with the saying, "Say you can't breathe, bitch. I can't BREA ... Shut your bitch ass up."
I have no knowledge of that, no.
Again, you don't dispute that the screen name for the defendant is DA Real T Streets, correct?
I know that he had a Facebook with that name, yes.
You pass forward the document, Your Honor.
Yes, ma'am.
And you were here for the trial this week, correct?
Yes.
And so you recall that that is the same name as the Facebook page identified by Mr. Lanier and is marked as exhibit number 5, correct?
It's the same Facebook name, yes. Yes.
We would ask that that be marked as the next exhibit, Your Honor.
And Ms. Pasley, any additional objections?
No, Your Honor.
This will be admitted exhibit number 169. It's a Facebook posting from DA Real REAL T dash Streets STREATZ exhibit 169.
Permission to publish, Your Honor.
Yes, ma'am, you may.
Sorry. And again, that document show the defendant's photograph and Facebook name, DA Real T Streets.
Yes. That's his photograph and that's his Facebook name.
And again, Facebook name, The Real T Streets. I'm assuming you didn't review the Facebook post from June 9th that stated, "Police try to snatch me up. They're going to need backup. Acting strange around me. Going to get clapped up."
No, and I didn't review any Facebook posts other than basically what would be a profile picture with a name. So I can't speak to anything that would have potentially been on his Facebook page because I haven't reviewed it.
You can pass forward the document, Your Honor.
Yes, ma'am.
Or maybe see this.
Yes, sir.
again, does that contain the same Facebook name and photograph of the defendant, the real T Streets?
It's the same name. The photograph is, you can't tell what it's a photograph of. The other issue I would say is that you can't tell what year this is. It says June 9th.
That is in fact the real T Streets Facebook name, correct?
That
That you
is,
identified before as being belonging to the defendant.
that Facebook name did belong to the defendant, yes.
And again, you were here for the trial, correct?
Correct.
And you observed when that document, exhibit number 5, for Mr. Lanier came in, where he identified that as the defendant.
Ms. Gangle, Ms. Paxton, any objections?
No additional objections, Your Honor.
Yes, sir. And this will be marked as Exhibit 170. The Facebook posting of the real T Streets. Exhibit number 170. Ms. Sandra, you may proceed.
Publish it for the jury, Your Honor.
Yes, ma'am.
And again, that document contained the Facebook name, the real T Streets, the name belonging to the defendant. Ms. Hall, once the defendant was in the federal system, he was provided,
Yes,
correct? He was provided access to mental health treatment, correct?
he was.
He was provided access to educational training, correct?
Yes,
In fact, he got his GED, correct?
he did.
And took some college classes online.
Yes,
And he was provided access to job training, correct?
that's correct.
And various other vocational training.
Yes.
Excellent.
Thank you, Ms. Bird. Ms. Gangle, any additional questions?
No, Your Honor. Thank you.
Ms. Hall, thank you. Ms. Sutton, watch yourself, please, ma'am.
Thank you.
Mr. Gangle, you may call your next witness.
Or maybe called Teretha Martin.
Teretha Martin, please. Martin, you come right up here to where Deputy Smith is standing, please, now. And once you get to the circle, if you put your left hand on the Bible, please, and raise your right hand. Yes, ma'am.
Do we approach?
Yes, ma'am. Ms. Martin, let me swear you in, and then you have a seat. Do you solemnly swear or affirm the testimony you give this cause to the truth, the whole truth, and nothing but the truth to help you God?
Yes.
You may put your hand down. Have a seat here, and then once you stand in there, while we have this discussion. Good afternoon. Will you spell and state your name for the record, please?
Teretha.
Ms. Martin, M-A-R-T-I-N? Is that correct? M-A-R-T-I-N?
Yes,
Ms. Martin, are you related to Mr. Wilbourn?
yes.
And how are you related to Mr. Wilbourn?
He's my oldest brother.
Ms. Martin, there's some objection that has been made at this point, and I've ordered that the rule of sequestration be imposed in a case. Fancy word. It simply means you can't be present in the courtroom during the course of the trial. And there's an allegation been made that you have in fact been sitting in the courtroom while this case has been going on. Now, have you been present in the courtroom through some of this trial?
I came, I think I came, when it was Saturday.
Yes, ma'am.
I didn't come no other day because they said that I couldn't come because they was going to call to subpoena me. But from my knowledge, I was told, that I can come now because they already questioned everyone.
So you're here on Saturday?
Yeah.
Or you're here on Sunday?
No, I
But you
didn't
did sit in the
come.
courtroom on Saturday to be part of the trial?
Yeah.
Mr. Gango, with you.
Were you in the trial?
No, they never called me.
Were you in the courtroom when witnesses testified?
No, it was over. Just what I said. No.
And this is on Saturday that you were here?
Yeah, I came Saturday today. Yeah, I came Saturday. There was no witness. This one, they was like it was over. They wasn't going to call me.
Right. So just to be clear, you were at 201 Poplar on Saturday, correct?
Yes.
No witnesses testified?
No.
But you wandered into the courtroom?
Yes.
How long were you here?
I don't know. I think it was here for like maybe 2 hours. Yeah.
But again, you heard no witness testimony.
No, it was over. This one, they was like they wasn't going to call me when I.
So you showed up because the state had subpoenaed you?
Yeah, I had came actually that Monday, and they was like they was going to call me, keep my phone on, and they was going to call me when they needed me to.
Okay, and did you show up just to make sure you didn't get into trouble?
Did I come any of them days?
No. On Saturday, did you show up because you were wondering why the state didn't call you?
Yeah, I just assumed that they wasn't going to call me because everybody, all the witnesses and stuff had talked, so I assumed it.
And is that why you came to court, just to make sure you weren't getting called?
And yes, not just that, I came to support my brother because,
No further questions.
Any questions from the state? Ms. Henderson?
Now, of course, when the state spoke with you, they said that we would call you if we needed you. Did you recall that?
yeah,
And we didn't call you, did we?
no,
But you came anyway Saturday, and you were here for some hours, correct?
yes,
And you were saying you sat in the courtroom for several hours Saturday, and no witnesses testified during that period of time.
no.
That's all I have to do.
Ms. Martin, when you were here for 2 hours or more, what was going on in the courtroom while you were in the courtroom?
I'm trying to see what actually went on. I can't really recall at this moment what they
What
was
time did you get
talking.
here on Saturday?
I think I made it here like at 11 o'clock.
And what time did you leave?
I probably left like maybe 3 something, maybe 3.
And you were in the courtroom the whole time, is that correct?
Yes.
Now, I told folks on Tuesday, Monday, Tuesday, Wednesday that you cannot be present in the courtroom if you participated and called as a witness, and the state told you they would call you if you would want to testify. Did anybody tell you to come down here on Saturday? Or you just came here because you were supporting your brother?
I just came, then I had talked to him. I assumed that it was over, as far as calling witness.
Now, who did you ask that of?
Huh?
Who did you ask that of?
Who did I ask?
Yes, when you asked somebody, was it over as far as calling witnesses? Who did you ask?
I had talked to, I was talking to my family members, and I mistakenly think I had talked to one of the lawyers, and it was like,
Which one of the lawyers?
I think I had talked to Laurie.
To Laurie, Ms. Hall? And did Ms. Hall tell you that you could be present in the courtroom?
No, she didn't tell me. She was like, she didn't know, but she think, that, I guess the part is over about the witness being called, but she didn't tell me to initially come, but she was like, she think it's over.
objections?
Yes, Judge, I knew that I had seen her in this courtroom, and I was wondering, we were at college, I didn't make any big deal about it at the time, but now she's going to testify, and the court knows what was going on during that long frame of time, and we would object to the violation of the rules of sequestration based on that.
It's fine.
The rules are more relaxed during the mediation phase, we know that, and also that if she did come forward on the day where there are no testimonies or witnesses that are closing out, a single person should be allowed to testify during the mediation phase of this trial.
It's fine. Ms. Martin, did you talk to anybody, any of the other witnesses about what they testified to in court?
No.
Did you talk to any of the family members about what was testified to in court?
No.
Gentlemen, would you approach?
Yes. Yes, sir. Thank you, ladies and gentlemen. You can be seated. Ms. Martin, a few minutes ago, you told me your name. You spelled it for the record, but for the ladies and gentlemen of the jury. Can you tell the ladies and gentlemen of the jury your name, please?
Teretha Mari.
And Mr. Gangle, you may proceed.
Thank you, Judge. Ms. Martin, how do you spell your first name, please?
Teretha.
And your last name?
Martin. Martin.
Ms. Martin, I'm going to ask you to keep your voice up, please.
Okay.
How old are you, please?
29.
Where do you live?
I live in Memphis.
You don't have to give your exact address.
Okay.
Ms. Gangle, you may proceed.
Yes, I work.
Where do you work?
I work at a warehouse.
All right. Do you know Tremaine?
Yes.
How?
He's my oldest brother.
You said oldest brothers. How many siblings do you have?
I have 6, and he's the oldest.
Where do you fit in the continuum?
I'm in the middle.
How old was Tremaine when you were born?
When I was born, he had to be like, I'm assuming 4, because I think he's 4 years older than me.
Where was your mother when you were born?
When I was born, my mom was incarcerated.
You know what your mom was in prison for?
She's been in prison for multiple things, from drugs to shoplifting to everything you can name. I mean, from drugs to shoplifting to,
Where is she currently?
She's in New Orleans now.
Is she, do you know if she came to the trial?
No, she hadn't come to the trial.
Okay. Who took care of you when you were an infant?
My grandmother,
What's her name, please?
Sandra Richardson.
How old were you when Tremaine came to live at Miss Richardson's home?
I actually don't know how old I was, but I knew I was. As long as I can remember, well, I do know he stayed with my mom for a minute, but as long as I can remember, I knew I was young. I was probably like, I don't know, I was young because where my granny stayed now, I knew I was like in the second.
Okay. Was Tremaine a good brother
Yes.
How?
He looked out for me. He gave me advice. Of course, he was a protector. He provided. He had to help. At an early age with my granny, since she was, a single parent, and he was the oldest. So I feel like,
Did Tremaine have a close relationship with your other siblings?
yes, with me and my brothers.
All right. Tell me about your mother, Andrea Martin.
When she came around, things was good, but we rarely seen her. So that, it made things like, difficult, and then like, I don't know. But she was.
All right. That's fine. What kind of relationship did Tremaine have with Andrea Martin?
When she was around, I guess things was okay, but it was like, he just said that he felt that she abandoned us. Well, she abandoned us, and she left him in foster care, in juvenile.
Okay. Did Tremaine talk to you about his relationship with Andrea Martin?
Yeah, we talked about it, We talked about it, and he was like, because he always told me he was proud of what type of mother I was, because he was like, we ain't had no mom, and we used to say, we ain't had no mom, and I was like, I was like, I kind of forgave her. He was like, he just felt like she just left us,
Do you think Andrea Martin's behaviors had a negative impact on Tremaine?
Yes.
Why do you believe that?
Because of some of the things when they stay with her, what they think, and this all we knew of her is, continuously back and forth in jail, and just, drugs,
After Tremaine was released from prison in 2014, where did he stay?
He came and stayed with me.
Do you have children?
Yes,
How many?
I have 2.
Was Tremaine good with your children?
Yes, he was great,
Did he interact?
Yes, he actually took on the role, as they uncle slash, like a dad. Like he helped me in a lot of areas, as far as taking my son to his football games, being at programs, participating in things, in a school, going to programs, just, taking my son to the barbershop, just helping me out in every area.
Would he babysit?
Yes, they loved him.
Was Tremaine trying to do well?
Yes.
After his release from prison?
Yes.
What was he doing?
He actually enrolled in school. I'm still getting mail for books, that was at my house. He enrolled in, I think it was ITT Tech. He was working at Technicolor. He was working.
After some time, Tremaine left your home. Was he at your home for about 7 months?
Yeah, he stayed with me for a little minute. It was maybe 7 months, maybe 6 months. I don't know. It was somewhere around it.
Why did he leave?
He was like, he just said he felt like he was taking up some of my space, and then he was like, it was just like he kind of felt closed in,
Did Tremaine have a car?
No.
After Tremaine moved from your home, where did he go?
He went to stay with my granny.
That's Sandra Richardson?
Yes, Sandra.
Did she live in Memphis?
Yes.
Does Tremaine have a good relationship with Miss Richardson?
Yes. He had a real close bond with her.
Okay.
I
How does he help her around the house?
He helps with everything as far as the yard, you know. He don't hesitate. Anything she asks of, he's there. Just everything. And she like her garden. She, you know, her grass, just everything. And he also spent time with her, you know. You know, I spent time with her, but I never really, like, took out time to do some of the things she wanted to do. Like, he would take out the time to go to bingo with her and also to the casino. I just felt like she stayed down there too long. I wanted to stay down there for no 3-4 hours. And he would. So.
You talked about your children.
Yes.
Did Tremaine have
Yes.
kids?
He had kids.
Did you take his children to see him in jail?
No, they didn't actually see. Well, they seen him once when he was incarcerated with their mom. But when he was in the Hale house, they seen him. But when he was released, he tried to make up time. He spent a lot of time with them, and they spent time with my kids, and we spent time taking them out and taking them to places. But you know.
Okay. Has Tremaine expressed remorse to you for Sean Bolton's death?
Yes, in so many words. And yes.
Objection, Your Honor. We approach.
Yes, ma'am.
Yes.
Proceed.
Did Tremaine have friends that were police officers?
No, not that I know of.
Thank you. No further questions.
Thank you, Mr. Gainville. Is there any questions of Ms. Martin on cross-examination?
Just briefly, Your Honor.
Yes, ma'am.
You said, Ms. Martin, that the defendant was very close to your grandmother, right? He's very close to you and your brothers and sisters, right?
Yes.
And you supported each other even though your mom was absent for most of your childhood.
Yes.
But around 2, when he was 2, when you were young, your grandmother took you and she raised you for the most part. Is that right?
Yes.
And even though it was hard for being a single parent, she did the best she could to give you the things you needed, right?
Yes.
And you indicated that the defendant tried to do the right thing or tried to do well when he got out of custody, correct?
Yes.
Do you recall that he went to the halfway house, but he was thrown out of the halfway house?
No, not to my knowledge.
You don't remember that?
No.
Do you remember that he had some positive drug screens and he wasn't supposed to be using drugs when he was on probation?
No, I don't remember.
You don't remember anything about
Keep
that?
your voice up just a
No.
little bit, it's trailing off. Thank you, ma'am.
Okay.
You may proceed, Ms. Bird.
But again, even though your grandma was raising you all by herself, she did the best she could, and you all looked out for each other. Is that right?
Yes.
That's what it's right.
Thank you, Ms. Bird. Mr. Gainville, additional questions of Ms. Martin?
There you are. Thank you.
I want to thank you for being in court today for your brother. I know it's a very difficult day for you also. We're going to excuse you from additional testimony in this case. You can sit and watch the rest of the trial if you want to, or you're free to go home now. You can step down from the witness stand and watch your step, Ms. Martin.
All right.
Thank you, ma'am. Watch your step down. Gainville, we have an additional proof you want to submit on behalf of Mr. Wilbourn.
Indeed, Your Honor.
Yes, sir. You may call your next witness.
Sandra Richardson, please.
Sandra Richardson, please. Richardson, good afternoon, ma'am.
Good afternoon.
Ms. Richardson, you come right up here to where Deputy Smith is standing, please, ma'am. And once you get to that circle, if you place your left hand on that Bible and raise your right hand, please. Ms. Richardson, do you solemnly swear or affirm the testimony you will give in this case be the truth, the whole truth, and not but the truth, so help you God?
Yes, I do.
Thank you, Ms. Richardson. Put your hand down. Have a seat here.
Okay.
Now watch yourself when you get up here, Ms. Richardson. Mr. Gainville, you may proceed, sir.
Tell me your name, please.
Sandra Richardson.
Richardson, I hate to ask you this question, but how old are you?
6 to 8 years old.
Do you live in Memphis?
Yes.
How long have you lived there?
I have lived in Memphis all my life.
All right. Are you working?
No, I have retired.
What's the last place that you worked?
Senior citizen,
And where is that located?
4700 Poplar.
Do you have children?
Yes.
How many children do you have?
5.
Please tell us their names.
Lionel, Allen, Perry, Adam, August.
Okay. Do they live in Memphis?
Yes, they do.
You know about how old they are?
Yes, I do.
Tell us, please.
52, 51, 48, 38, 37.
Ms. Richardson, do you know Andrea Martin?
Yes, I do.
How?
She was spending time with my son, Allen.
Okay. There's a person named Donnie Martin. Who is that?
Donna Martin is Adria Martin's second child. That's my grandson.
How old was Miss Martin when you met her?
She was about 19 years old.
How long have you known her? How long have you known her?
About 32 or 33. I had to go with Tremaine age because he was 6 months old when he came into my life. So I said 32 or 33. No, 32. I think Tremaine age.
Yes, ma'am. When you met Miss Martin, she had Tremaine already?
Yes, she did.
And Tremaine was about how old?
6 months old.
Okay. What do you know about Andrea Martin's background?
Adria Martin was really raising herself. You know, she lost her mom and her dad at an early age. So she got to her age and stuff, she just kind of did what she wanted, so she was really a streetwalker.
So Miss Martin's lifestyle was that she walked the streets?
Yeah.
How do you know this?
Just through the neighbor talking when she used to come on my house looking for my son, he wasn't there. And, you know, they call her a prostitute, but I call her a streetwalker.
How was Tremaine?
Even with her doing what she wanted to do, she would leave him with other people. And other people would come around my house looking for her with Tremaine. And one day they came there looking for her with Tremaine. And they could not find her, and they were talking about they were going to take him to juvenile court. I said, don't do that, give him to me. And then when she come home, just till I got him. But really, I fell in love with that baby.
How often did you see Tremaine when he was an infant?
Well, I seen Tremaine quite often because his mom would go on pillar to post. So really, on weekend when I'm off, I would keep Tremaine. Holidays and things, Tremaine would be with us as me and my family. Not Miss Martin, but it'd be Tremaine. But there's no way that she would not come back and get him because I had to work. But then even with her not coming to get him, I always was blessed to have babysitters because Adam and August were still at home with me and they were still little.
How old was Tremaine when Andrea Martin had died born?
Tremaine was about 2 years old. I think Tremaine was about 2 years old.
Where were you living when Tremaine and Donnie were infants?
I was living in a Cleveland home, Memphis Housing Authority, 17 apartment F.I. Oka.
And when did you move?
I moved about 2 or 3 different places before I moved over there on Kentucky Street in my own house.
Okay. So how did you come to have custody of Tremaine and his siblings?
Miss Mom was going through a loss, and it came to a point that she would just, she would get her places. She would have places. But then she started getting rested. Then I had to get the children. They try to keep the children together. My purpose was trying not to let the state get the children. it was my purpose to keep them children together as a family. So when mine get ready for them, she'd be able to get killed. And she always had a place to come and visit them. Whenever she walked, I never closed my door to her. But if she get aggressive with me, she know north, south, east, and west, go and leave me and these children alone. She knows that. In an aggressive way that she may get smart with me. She never do no bodily harm to me. But she knows she always had a home with me and them children. That's the most important of all.
Teretha Martin.
Yes,
Where was Teretha Martin?
in the hospital.
In the jail?
Yeah, Miss Mom was doing time. Yes, she was doing time. And she was born in a hospital.
Okay. Did you get custody of Teretha?
I could not go to the hospital and get her because they said I was not no legal kin to Miss Martin. So I had to ask Joanne, her sister, to go and get that baby for me. And to me, Teresa was three days old. And she went to the hospital and got that baby. That way I was able to keep that baby with the family.
How were you able to afford all these kids?
With my income on me working, and I was getting food stamps, and I was getting a Medicaid, and my family member would help me. But know what? It's a wonder. I was blessed. I was blessed. Because the state would not give me the money for the children, because they said the children was not no legal kin to me, because I didn't want nobody to take them children from me. So my concern was about them children.
Was Andrea Martin able to take care of her kids for any period of time?
She could have, but Andrea Martin was more of herself and less of the children. But I think when they wound up with me, I think that she was more comfortable. I know what, I was blessed. I think Andrea Martin looked at me as a mother figure. Even with her and my son not together no more, I think she looked at me as a mother figure.
Did Miss Martin use drugs?
Out there doing your thing, you never know what you're into out there. I mean, I would never know what she into, because you out there.
How old was Tremaine when he came to live with you?
Tremaine was about 12 years old because it was a point in time she had put him in youth village, but I had the other children. But me and the other children would go to youth village and see him, and that's how Department of Human Services found out that I had the children. Because we found out where it was, I would go and visit him. At least me and the children would walk down there and go and see him.
Was Tremaine Miss Martin's last child to come live with you?
Yes, Tremaine was.
You know why? Why was that?
Because he was in youth village. He was in youth village, and I think that's what they said. The state have cussed up him for a while when you put him in a place like that, and he can only come after they realized they come and see how my household was and how it was with the children. Before they let him come and visit, he started off visiting with us first. Then as time went along, they said that they will give me custody of Tremaine with the other children.
You talked about Andrea Martin going from pillar to post. Have you had contact with her throughout the years?
On and off, but for now, she is in New Orleans, and I have not talked to her in about 6 months now. She really is in a halfway house, so she just up there.
Has she been in and out of jail and prison?
I said yes, on and off.
Did Tremaine look out for his younger siblings?
Yes, Tremaine helped me a lot out with the children. Even around that, Tremaine helped me out. He helped me out.
How did he help you out, please?
Just everything that you would ask of a child to do, and him growing up in your house. But once he got to a certain age, he left me maybe about 17 years old because he met a young lady across the street from me, and he moved in with her.
Was Tremaine respectful to you when he lived with you?
Oh yes, sir. Because Tremaine know I didn't play. I didn't, I love the children, but I do get on them. And they know how far to push that button now.
Did Tremaine help you with household chores?
Yeah, that's something that they had to do to help me with and everything.
Okay. You got a son by the name of Adam Mackey.
Yes. Uh-huh.
What kind of relationship did Tremaine have with Mr. Mackey?
Remember, August and Adam was the only two people left at the house, with 2 children left at the house with me. My oldest boys had already left me. So they grew up together with each other.
Okay. Now, Adam and Tremaine, did they commit a crime together?
Yes, they did. Yes, sir. Yes, sir. But at that time and moment, they was not living with me. Adam had his friend, Tremaine had his girlfriend, so they was away from me. But they did commit a crime together.
All right. And how do you feel about Adam and Tremaine's crime?
I don't feel nothing, because that's the stage in life that they had to go through with, that they did. That is nothing that reflects me, that would bring nothing on me. That's something that they did.
Okay.
Yes, he did. Yes, he did.
Was Tremaine thankful to you? He expressed gratitude to you for taking care of him and his siblings?
That's something that has always been natural with them children. They always have appreciated me. They have always appreciated me for being there for them.
Does Tremaine have any children?
Yes, he have 3.
Have you seen Tremaine interact with children?
Well, when Tremaine got it, Tremaine always have been involved with his children. But when he got out, he would go over to the school to check on Bree and check on little Tremaine and everything. But the other young lady that had custody of Tremaine's daughter, she did not want Tremaine to be around her daughter. You know, she didn't want that relationship with Tremaine around her daughter.
Okay. Is there anything else that you want to tell the court?
Nothing else. Nothing else. But you know what? Lord, I thank you. I thank you. Because I know something that nobody knows. Lord, and I'm going to tell you, the 5th, the 10th, 2015, I had a dream. And in my dream was this baby.
Approach, please. Ms. Richardson,
Yes, sir.
I know there's some things that you want to say, but I can't let you say everything that you want to say.
Yes, sir.
Mr.
Right.
Gangula's going to ask you some questions.
Okay.
And if you can, listen to Mr. Gangula's question and answer that question, because we can't allow you to speak in a narrative.
Yes, sir.
And you have to answer
That's
the
right.
question, because you might say something that could be good for your grandson. I'm sorry for your grandson, Mr. Wilbourn. It could be something that could hurt him.
Yeah.
So don't volunteer anything about what you dreamed about. So listen to Mr. Gangula's question, please.
Okay.
That's okay. I know you don't know.
Yes, sir.
Mr. Gangula, you may proceed.
Do you still talk to Tremaine?
Yes, I do.
Do you love him?
Yes, I do.
No further questions, Your Honor.
Thank you, Mr. Gangula. State you have any questions, Ms. Richardson?
No questions, Your Honor.
Ms. Richardson, 68 years young.
Yes,
You're still
sir.
a young lady.
Yes, sir.
I want to thank you for being present in court today. I know this is a lot that you and your family are going through also. And I want to thank you for your patience and getting this case tried. You may step down from the witness stand and watch your step.
Yes, sir.
You can stay and watch the rest of the trial if you want to at this point, or you're free to go home now.
I'm ready to go home.
You ready to go home?
Yes, sir.
Thank you, Ms.
I
Richardson.
thank you.
Yes, ma'am. Be careful going home. The weather's a little bit bad out there.
Yes, sir. Thank you.
Yes, ma'am. Mr. Gangula, Ms. Pastor, Ms. Paul, do you have any additional proof to submit on behalf of Mr. Wilbourn?
Your Honor, they still with the jury. That would be our proof.
State you anticipated a rebuttal proof.
No, Your Honor.
Ladies and gentlemen of the jury, there are a couple of other legal things I need to address with the lawyers, and actually retired to jury in this case at the sentencing part of the trial. We'll talk to the lawyers about some legal issues, and I will see you in a few minutes. I'll follow that please. You still cannot discuss the case with anyone or amongst yourselves. For the record, the jurors out. This is, of course, the intention. It is 419-420. What I intend to do is to finalize the sentence and instructions on the charges for the sentencing hearing, will charge the jury tonight to allow the lawyers to submit their closing arguments tomorrow morning at 9 o'clock. And I've given a proposed copy of the charge to the lawyers. Have you had a chance to review the proposed charge? And I noticed the things that probably, I think the state would have some objections to some of the things that have been submitted as possible mitigating circumstances that Mr. Ganguli has proposed, and I put all of those in the proposed charge. Any objections, any recommendations, or anything that you want added or deleted? Ms. Berger.
Yes, Your Honor, we do object to some of the suggested mitigating circumstances. As to number one, I don't know, the defendant was 33 at the time of the crime. I don't know that that applies, and leave that to Your Honor's discretion.
And as far as the youth of the defendant at the time of the crime, he was 30.
It was 29.
29, 30, 33, or 32.
We rely on
Youth is in the eye of the fact finder. So I cannot comment to whether or not he's particularly young or old. Mr. Ganguli believes that 29 is relatively young. That's an argument that he can in fact make. So I will charge it. But whether or not the jury finds that he was young at 29 is a factual question. So I will in fact leave that in.
Or number two, the capacity of the defendant to appreciate the wrongfulness of his conduct. I don't think that this aggravating circumstance has been raised by the evidence.
We've heard proof that
I'm sorry, mitigating circumstance.
Mr. Wilbourn suffered from post-traumatic stress syndrome, and depression with psychotic features. In July of 2015, less than a month before the crime.
That is one of the statutory aggravating circumstances. There's some language in about intoxication, which has not been raised by the proof, but the capacity of the defendant to appreciate the wrongfulness of his conduct, to perform his conduct to the requirements of the law, was substantially impaired as a result of a mental disease or defect, or it is something on record and sentence that indicates Mr. Wilbourn, in fact, was suffering from depression, post-traumatic stress disorder, also psychotic episodes, and that has been fairly raised by the proof. And the mitigating factor is something the jury does not have to determine unanimously, but if there's anything on the record that could support it, the court has to charge it. I would strike the or intoxication because there's nothing on the record that indicates Mr. Wilbourn was in fact intoxicated, so I would strike that language as being surpluses. But the rest of it has been raised by the records that have been presented through this call. So I will leave the rest of that in.
Thank you, Judge.
Ms. Berg.
Sorry, Your Honor. Which?
I will strike the or intoxication part because it's not on the record to support intoxication. Yes, ma'am.
I think the state's position, Your Honor, was not that there hasn't been testimony about a mental disease or defect, that there's been no expert testimony in the vein that you would have for diminished capacity or insanity that would indicate that the defendant was not able to appreciate the wrongfulness of his conduct or to conform his conduct to the requirements of law based upon that diagnosis. And so that's the portion I think that we're objecting to.
Let me take that under advisement, and I will include or exclude it after I've looked at a case on it.
Thank you, Your Honor.
Ms. Berg, you may proceed with any other objections. Number 4, which Mr. Ganguli had indicated he wanted included, I will strike the impact of the death sentence on the defendant's family. That is not something that has been raised by the proof, and that is actually asking the jury to return a verdict on an emotional basis rather than on a factual basis, and that's not a statutory mitigating circumstances, something Ms. Ganguli would ask the court to consider, but that has not been raised by the proof, and I cannot tell the jury to consider the impact that a death sentence will have on the defendant's family, so I will in fact strike that, Mr. Ganguli.
Judge,
Yes, sir.
I understand your position. Would you please take
I would take, yes, sir.
4 under advisement and find your attention to State v. Hawkins?
I would take it under advisement, Mr. Ganguli, but at this point, I will exclude it, but I will look at Hawkins again, Mr. Ganguli. Anything else, Ms. Berg?
The number 5, the defendant's limited formal education. Although there was testimony about him being removed from school for an incident that he was involved in regarding a weapon, he He did get his GED. He also took college courses while he was incarcerated.
But he didn't finish high school.
He didn't finish high school, does have a GED, was enrolled in college courses. Again, that's a factual issue as to whether how limited formal education is. If Mr. Ganguly wants to argue that statement, certainly argue that Mr. Wilbourn has, in fact, in high school general equivalency diploma and was, in fact, taking college courses. It may be contradictory, but Mr. Ganguly wants the jury to consider that his formal education was limited. That's a fact issue. I will, in fact, charge that as a possible mitigating circumstance.
Number 8, Your Honor, while there was some considerable testimony about the difficulties with the defendant's mother and his upbringing, I do not believe that there was specific testimony that the defendant suffered physical or sexual abuse.
Mr. Ganguly.
As to number 8, we agree that the phrase "and sexual abuse" should be removed. Regarding physical violence, I think the courts heard testimony that Andrea Martin beat Mr. Wilbourn regularly.
Mr. Ganguly, the testimony that I heard that I remembered, again, I can't comment on the proof, is that she tried to discipline her son, and when she would try to whip him, that he would run away from home. So there's no indication that she beat him. All children, most children, probably, in most households, receive some form of discipline, including whippings. So there's no indication that it was opposed to physical violence, but simply that his mother would, in fact, punish him, or would attempt to discipline him, and could not, and would ask that he be removed from the home because he kept running away from home to try to discipline him. There's nothing on the record that indicates that she physically abused him or beat him, but she simply tried to discipline her child, and it did not work. So the allegations of physical violence, there's nothing on the record that would support physical violence.
Would the court consider charging merely any exposure of the defendant to abuse? I think Mr. Wilbourn told Alliance Healthcare about abuse.
I don't think that was testified to there, Your Honor. And I do believe that number 12 encompasses some of the things that they're discussing, which is the lack of appropriate parenting skills, adequate parental supervision.
I think mention of the abuse was in the PowerPoint and in Ms. Hall's testimony.
Looking through my notes, Ms. Hall did testify to alleged abuse and neglect, her words, by his mother. So that is before the jury, alleged allegations of abuse and neglect. So I will modify this to any exposure to defendants to physical abuse by his mother. Ms. Berg.
Yes, Your Honor. Looking at number 15, it's the state's position again when Your Honor reviews number 2, that this is the more appropriate statement as the proof that has been presented, and not number 2.
So number 2, defendant's mental health problems before the crime, and not what number 2 is actually state's position. That's a legal finding that would have to be supported by some expert testimony that would indicate he was unable to appreciate the wrongfulness of his conduct or to perform his conduct to the requirements of the law that would require some expert proof, where number 15 does address any mental health problems before the commission of the crime. So that's the state's objection of number 2, Mr. Ganguly. In response to that objection, Ms. Bird has indicated that it's sufficiently covered by number 15.
One moment, please.
Yes, sir.
Currently, our position that Factor 2 deals with the crime itself, whereas Factor 15 deals with the circumstances leading to the crime.
Your Honor, and number 2 is specifically those things I mentioned: diminished capacity, insanity, none of which is testified to, and all of which requires an expert to make that nexus.
And therefore, we ask, if anything, that 15 be struck and 2 be left in.
And I would consider the request 15 is more accurate with what's on the record. 2 is actually asking for some finding by some competent person that he was unable to appreciate the wrongfulness of his conduct or to conform his conduct to the requirements of the law. And that is asking for essentially an expert opinion regarding a mental disease or defect. There is nothing on the record that would support that. There is something on the record that indicates he does have mental health problems, but again, I would look at a case. At this point, I'm inclined to leave number 15 in and to delete number 2, but I will make that decision in a few minutes. Ms. Bird, any additional concerns?
Number 20, Your Honor, the defendant's remorse. There has been no expression by the defendant, no proof to the record to support a finding of the defendant's remorse.
Mr. Gangoley?
Was it better?
In remorse, those questions were asked by witnesses as to whether or not Mr. Wilbourn had expressed remorse. And I've actually struck through that with a question mark, but Mr. Wilbourn has in fact expressed remorse. I will go back and review my records. If there is, I will leave it in, but at this point, I am probably inclined to take it out. I did modify, but this is number 19, before submitted to lawyers. The defendant's admission of guilt to, I think it was these crimes, and I modified it to some of his crimes, which is a more accurate reflection of what the record is. He did not admit guilt to the first-degree murder that he's been convicted of, but he did admit guilt to some of his crimes. So I modified that to read some of his crimes.
With respect to the remorse,
Yes, sir.
I think Teretha Martin would have testified that Mr. Wilbourn was remorseful. There was an objection. The court sustained the objection.
Yes, sir.
But had there not been an objection, there would have been testimony regarding remorse.
There was an objection.
There was an objection, and had the state not objected, I believe Ms. Martin probably would have testified about statements that were made by Mr. Wilbourn, things that Mr. Wilbourn had told her, and that would be hearsay.
How was there an objection?
Out of court statements made for the purposes of the truth asserted in those statements, rather, the state of Tennessee would not be able to cross-examine or to ask questions about that, and there was a question asked as to whether or not the defendant has expressed remorse, and the objection was made at that point. So there's nothing on the record I did sustain the objection because it was asking her to testify about hearsay statements that Mr. Wilbourn may have told her at some point. Ms. Bird, I apologize if he interrupted you when you were speaking.
No, Your Honor, I don't think I interrupted you. I apologize. Number 17, I don't think it provides any clarity. This is one of the non-statutory aggravating circumstances, and as it's written, it appears to violate the rule that there should not be a specific comment on the evidence by Your Honor, and I'm not really sure that it's clear that you're not commenting about that.
The undeveloped potential, don't know of anything that was specified on the record about what that undeveloped potential may have been.
Or I think there was testimony regarding Mr. Wilbourn's being good with children. Mr. Wilbourn held paper chores around the home when he was a child. And that the depression affected his ability to function once he was released from prison. And so we would submit that Factor 17 does apply.
When I review that, Mr. Gangle will find that it does apply, but if there's testimony on the record that he was, in fact, helpful around the house, he helped his grandmother, he helped his sister, he did housework for his grandmother, but nothing on the record that says that Mr. Wilbourn had ambitions to become a doctor or a lawyer or a school teacher or some other occupation that somehow he was thwarted in not developing that. So not developed potential, that's a nebulous phrase that really doesn't specify any particularities as to what might be. But I'll take a look at it. At this point, I don't know what on the record would support that he had potential that was in fact underdeveloped because it appears as if those things that he wanted to do, he was working. Was frustrated at some point because he was not working enough hours, but nothing that says he had the potential to do something else and somehow was stunted or prevented from doing those things. So we'll take a look at it. At this point, I'm inclined to delete it. If I choose to delete it, it will be deleted. If not, it will be in the final list of mitigating circumstances. Anything else you want to say in objection regarding those other proposed mitigating circumstances?
No, Your Honor.
Any objections to any of the rest of the charge, proposed charge?
No, Your Honor.
Any objections to any of the rest of the proposed charge?
No, sir.
My understanding, and I do need to clarify, and I would add more to this or not, but I've added a limited instruction on evidence of other acts, and I'm required to do that by State versus Sims, SIMS. Capital murder case that I tried in criminal court division 5 before Judge Daly. And there were some other acts that were admitted to rebut certain things that have been raised in mitigation, and the judge allowed, the court in that case allowed the state to ask those questions regarding other bad acts to rebut allegations that the defendant in that case was in fact a law-abiding person, and it was character proof that actually came in, and the court had ruled that the state in fact may use that to rebut mitigating evidence. In that case, the Supreme Court of the State of Tennessee, Sims is 45 Southwest 3rd, page 1 of 2001 Tennessee Supreme Court opinion, and State versus Stout, STOUT, Sims is SIMS, 46 Southwest 3rd, page 689 of 2001 Tennessee Supreme Court opinion. Those are cases that I tried. The Supreme Court ruled on those in 2001, and both of those had prior bad acts that were admitted in a sentence appearing to rebut mitigation proof. And in the Sims case and in the Stout case, the Supreme Court held that other bad acts are relevant to rebut certain mitigating testimony, but the court should give a limiting instruction before allowing the jury to consider evidence of prior bad acts. And in those cases, the Judge Daly did not give that limited instruction, and the court held that it was error, but it was harmless error on those cases. And on limited instructions, this court has to specify exactly what those other prior bad acts are to make sure the jury is unanimous of whatever bad acts they are considering. I can just not tell them bad acts, and that's why I've specified those ones that were raised during the course of the trial, not today. Acts of failed drug tests, throwing gang signs, being fired for threatening a co-worker, being involved in alleged gang activity. There's been some other things that came out today, I believe, during Ms. Hall's testimony, that bad acts of fighting and refusing orders while in custody and possessing dangerous weapons while in custody. Those are other bad acts which have come out in today's testimony. I do need to amend the evidence of that other acts rather to include those specific instances, because they have to make sure Sims and Stout have indicated that if other bad acts are raised, because one of those cases where the judge has to specifically indicate what those bad acts are, will tell the jury that if such evidence of other acts is considered by any purposes must not be considered for any purpose other than that specifically stated, and that is limited to limited purpose of determining whether or not it provides rebuttal to the mitigating circumstances that have been raised by the evidence. So I do need to amend that to include those two particular other alleged bad acts. Any objections to that, or any other objections to the charge as proposed?
Yes, sir.
This court will stand in recess for a few minutes. Again, what I intend to do is make those corrections, bring the jury in, charge the jury, recite the jury until 9 o'clock tomorrow morning, and we'll start arguments on the sentencing phase of the trial at 9 o'clock tomorrow morning. We call the court into recess and work in main seated.
Court stands in recess.
The record is this continuation of the State of Tennessee versus Tremaine Wilbourn, docket number 1600515. Mr. Wilbourn is present. All trial counsel are present. The jury is out. Both sides have rested at the sentencing phase of the trial. Mr. Ganguli, Mr. Wilbourn, you have a right to testify at sentencing also. Do you understand that, sir? And Mr. Ganguli is going to call you back to the witness stand to make sure you understand you have the right to testify or not. And if you choose to testify at sentencing, you may do so, Mr. Wilbourn. But if you tell them just call if I choose not to testify at sentencing, I would tell the jury the same thing I did at the conclusion of the trial, the guilt phase of the trial, that they cannot vote against you for any reason at all. But Mr. Ganguli does have to answer those questions under oath, sir. Mr. Wilbourn, you come up, please, sir.
Please come to the circle, Mr. Wilbourn. Raise your right hand, please.
Mr. Wilbourn, do you solemnly swear or affirm the testimony you give us this hearing will be the truth, the whole truth, and not but the truth, so help you God? Thank you, sir. You have a seat right here, please, sir. Mr. Wilbourn, good evening, sir. Mr. Ganguli, you may proceed.
Thank you, Judge. Mr. Wilbourn, you've got the absolute right to testify at your sentencing hearing. You understand that? You've got the absolute right to remain silent at your sentencing hearing. You understand that?
Yes.
We've talked in the back, is that right?
Yes.
And by we, I'm talking about Ms. Paisley and Ms. Hall, and I've met with you in the back. Is that right?
Yes.
We've met in the back several times throughout the day. Is that right?
Yes.
As well as yesterday. Is that right?
Yes.
You understand your rights and your options regarding sentencing. Is that correct?
Yes.
Do you wish to testify or do you wish to remain silent at your sentencing hearing?
I want to testify, but I'm not going to testify.
Okay. Did anybody force you into not testifying?
No.
All right. That's your decision, freely and voluntarily.
Yes.
No further questions, Your Honor.
You understand? You told me that you want to testify, but you have chosen not to. Is that correct?
Yes.
Now, is anybody making you do that? Is that something that Mr. Ganguli has told you? Ms. Pastor, Ms. Hall? Was that your personal decision, sir?
It was a personal decision.
Personal decision. You know, if he's testified at sentence, Mr. Wilbourn, you may testify and offer any testimony that you want about the mitigating circumstances. And again, mitigating circumstances, reasonable. Mr. Ganguli, Ms. Hall, Ms. Pastor have indicated to the jury that they should not sentence you to death. You understand that? And if you testified at sentencing and limited your testimony only to that, the state of Tennessee could not ask you any questions about what you did or what you did not do when when Officer Bolton was killed. They can't ask you any questions about the facts of the case if you limit your testimony only to the mitigating circumstances. But if you volunteer some information, the state then would have discretion to ask you wide open questions about everything, including what happened, what did not happen, and everything else involved in the case. You understand that, sir?
I really don't.
You really don't. At a sentencing hearing on a capital murder case, you can take the witness stand. You can tell the jury those things that Mr. Ganguli has indicated are mitigating circumstances. We discussed those before the break. I've given that to the lawyers now. I think there are 17 of those that are mitigating circumstances. You can testify about those things without the state being able to ask you about what you did or what you didn't do, unless you say something that make it relevant. Then they can ask you about what happened. But otherwise, they cannot ask you what happened. You understand that, sir? They cannot ask you, let's go back and talk about August 1st, 2015. What did you do here? What did you do there? Why did you do that? Why did you do that? They cannot ask you those questions unless you make it relevant somehow. You can take the witness stand. You can testify about those 17 things that are listed as mitigating circumstances, and the state would have to ask you questions only about those mitigating circumstances. You understand that, sir?
Yes.
But if you say something else that opens the door to other things, then they can ask you about what happened. They can talk about the whole night of August 1st, 2015. You understand that?
Yes.
Ms. Ganguli, additional questions to Mr. Wilbourn? Do you have any questions of the court right now, Mr. Wilbourn?
No.
And when you tell them to just coffee, I want to testify, but I've chosen not to testify. Is that your decision, sir?
Yes.
Has anybody corrected you, promised anything, put any force or pressure on you in order to get you to make that decision?
No.
Again, if Mr. Ganguli, Ms. Hall, Ms. Pasley talked about the possible good things that could happen if he testified, about the possible bad things that could happen if he testified.
Yes, it wasn't any good thing.
No good things. Thank you, Mr. Wilbourn. Step down, sir.
Thank you.
Thank you, sir. For the record, court again, defines pursuant to Moment versus State, Mr. Wilbourn has been advised that he has the right to testify at his sentencing hearing. The court finds Mr. Wilbourn understands that he testified at the sentencing hearing, the state would not be able to ask him questions about the circumstances of the offense for which a jury has found him guilty, unless Mr. Wilbourn somehow made those relevant or opened the door to those facts and circumstances. The state would be limited to asking Mr. Wilbourn questions only about those matters that are relevant to the mitigating or enhancing mitigating factors. And Mr. Wilbourn has made, again, an intelligent and a knowing decision to remain silent and not to present testimony of his own at the sentencing hearing. And the court has, in fact, to fulfill his obligation for Mr. Wilbourn that if he testified, if he limited his testimony on the direct examination to the mitigating circumstances only, the state of Tennessee would not be able to question him about the circumstances of this homicide case pursuant to State versus Cazes, C-A-Z-E-S, 878 Southwest 2nd, that's at page 266. And this court does, in fact, find that Mr. Wilbourn, pursuant to Moment, 18 Southwest 3rd, 1999, understands that this is a fundamental right to testify or not, and he has, in fact, waived his right to testify at the sentencing hearing. Now, I indicated before the break that it was the court's intent to charge the jury and argue the case at 9 o'clock in the morning, and over the break, I believe the lawyers asked him to just call, can we discharge and argue this case at 9 o'clock tomorrow morning. Is that correct? Yes, sir. We'll bring the jury in, let them know that there's no additional proof, and let them know that the legal discussions that we have to talk about outside of the presence. And instead of starting this process tonight, we'll start it first thing in the morning at 9. Deputy, if you bring the jury, please, sir. Yes, sir. Thank you, ladies and gentlemen. Everyone be seated. Ladies and gentlemen, I told you that I was going to read the charge to you tonight and upon further reflection. It is 5:25, and instead of reading this charge to you tonight, we're going to present this tomorrow morning to you at 9 o'clock. We're going to start promptly at 9 o'clock, and once I read the charge to you, hear Laurie's arguments on the sentencing phase of the trial. This charge is not very long. It's a total of 15 pages. And the charge you have is dated for today's date because it was, in fact, my intention to read this to you today. So we have November 5th on it. I'm not going to redo the charge, but we're not going to charge the case tonight. You cannot discuss the case with anyone. You cannot discuss the case amongst yourselves. You've heard all the proof that you will hear on this case. It will still be inappropriate for you to discuss this case amongst yourselves until you're back in the jury room deliberating on the law on this case. And I will read all of this law to you tomorrow morning. We'll explain the law to you. If you have any questions, make sure you ask of me all those questions before you retire to deliberate. Let me know if your accommodation's okay. Let me know if the food is still edible. And let me know if the deputies are treating you well. And we'll start tomorrow morning promptly at 9 o'clock. I think you have 51 other cases set tomorrow morning, but we'll handle those cases once you have started to deliberate on this case. I want to thank you for your patience today, and we'll see you back at 9 o'clock tomorrow morning. Thank you. I'll call the deputy speak, please. For the record, the jury is out of any matters that need to address before we adjourn. Yes, sir.
Yes, sir.
Court stand adjourns 9 o'clock tomorrow morning, Tuesday, November 6, 2018, for the continuation of the trial setting.
All rise. Court stand adjourned tomorrow morning, 9 a.m. See you on the trial.